Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's webinar hosted by immigrationquestion.com, a networking platform where immigrants, families, advocates, and licensed immigration attorneys come together to learn more about U.S. immigration policies and procedures. My name is Simia Murat, and I will be your host for today's discussion. Naturalization eligibility, residence, physical presence, and good moral character requirements. Now, applying for U.S. citizenship is an extensive process. Before filing for naturalization, lawful permanent residents must satisfy specific legal requirements related to residence, physical presence in the United States, and good moral character. Each requirement is reviewed independently, making it essential for applicants to understand how USCIS evaluates eligibility. To help us explore today's topic, we are honored to be joined by attorney Mary Radzimowski, a dedicated immigration attorney with more than 25 years of experience representing individuals in immigration matters. Her practice includes extensive work with U.S. citizenship and immigration services, and she's a member of the American Immigration Lawyers Association. Attorney, thank you for joining us today. We're delighted to have you.
Well, it's wonderful to be here with you.
Now, before we begin, immigrationquestion.com is a public educational and networking platform. The information shared with you today is for general informational purposes only and does not constitute to individualized legal advice. Whether you're joining us on Facebook, YouTube, LinkedIn, or another platform, welcome. Please subscribe and share this session with anyone who may benefit from learning more about naturalization, eligibility, and the citizenship process. Now, let's dive straight into the discussion. Attorney, to begin, can you explain what are the eligibility requirements for naturalization under U.S. immigration law?
Well, you have to be at least 18 years old and you have to be a legal permanent resident. Now, there is a required period of residence. It's usually 5 years. You have to be a legal permanent resident residing in the United States for 5 years, except if you're married to a U.S. citizen. In that case, the period of required residence is only 3 years. Now, half of that residence period, for half of that residence period, whether it's 3 years or whether it's 5 years, you must be physically present in the U.S. So if you have a 5-year legal residence period, like most people do, you have to have been physically present in the U.S. for at least 2.5 of those years. And if you have a 3-year continuous residence period as the spouse of a U.S. citizen, you have to have been physically present in the United States for 1.5 years. You have to have resided in the service district in which you are applying for 90 days before you make your application. The service district is simply the district in the area of your local USCIS office. So, for example, if you know that you're going to be moving 2 months from now, you probably wouldn't file a naturalization application today. You probably would want to wait until you move and then file it. Live in that district for 90 days and then file in that. Otherwise, you would have to move your case, and that can be very cumbersome and take up time.
Okay. And now in terms with continuous residence, what does that mean for the naturalization process? And how does USCIS determine whether an applicant has maintained continuous residence?
Well, for purposes of naturalization, residence is simply your domicile. That is your principal actual dwelling place, regardless of what your intent is. They look at where you are actually living. All right, so you actually have to have had a residence here in the United States for the required number of months, and you have to have lived, have claimed that or had that as your actual residence. Mm-hmm. Now, you are allowed to have certain periods of absence for naturalization, but for example, you can have an absence from the United States of up to 6 months. I always tell people to keep their absences under 6 months if they intend to apply for naturalization, because if in that required period of residence there is an absence of 6 months or more, there is a rebuttable presumption that you have abandoned your residence unless you can prove to USCIS that you actually did not intend to abandon your residence. Now, how do you do that? Well, you could show ties to the United States that were maintained during that period of absence. Like, for example, you maintained a residence here and you had full access to it. You had a job that you never quit. Your family, your immediate family, your spouse and your children under 18 were still living here in the United States. And very importantly, you did not take employment outside of the United States. Mm-hmm. Now, if you can show all those things, then in some cases, a period of absence for more than 6 months can be justified when you're applying for naturalization. But I would say keep the absences under 6 months if you want to be on the safe side. Now, that the 6-month absence is a rebuttable. There's a rebuttable presumption that you abandon your residence. But if you would go as far as a year, 1 year outside the country, you would be totally eliminated from applying for naturalization with no recourse until you satisfy the residence requirement all over again. So absences of 1 year or more will disqualify you with no way of recovering your residence.
And how is physical presence requirements different from continuous residence, and why is this distinction important?
Because USCIS wants to make sure that you have actually been present in the United States for a certain period of time. Physical presence simply means exactly that. You were physically present in the United States. Right. Now, it's very important to USCIS that you should be physically present for a certain amount of time, because that's the only way you can soak up the culture, you can acclimate yourself to life in the United States, and really know what you're getting into when you take U.S. citizenship. I mean, they want people who apply for citizenship to know what the country is all about, to know what our culture is all about, what our values are all about, and what our way of life is all about. And the only way you can do that is if you're physically present here for a long enough time. That's why they have the physical presence requirements. The difference between residence and physical presence is residence is simply that period of time when you had your principal domicile here in the United States, even if you were traveling, even if you took vacations abroad, spent some time abroad, as long as you maintained your ties, you maintained your residence here, you had access to your residence here, your family was here, and you never accepted a job overseas, you can show that you really did maintain your residence, even though you were not physically present, as long as that absence is 6 months or less.
Okay. And now moving to good moral character, it's one of the most discussed naturalization requirements. So how does USCIS evaluate this during the naturalization process today?
Okay, well, USCIS looks back at that 5 or 3 year period of continuous physical presence that is required for naturalization. Mm-hmm. And they look not only at whether you picked up any criminal charges or convictions, they take a holistic approach to this. They look at your entire life, totality of the circumstances, so to speak. They look at your character, they look at your background, They look at everything, including your employment background, your family background, your education, what you've contributed to the society, what you've contributed to your family, any positive things that you might have done, like volunteering in the community, community service, things like that. And all these things come into the determination of good moral character. Now, there are some things that could completely eliminate you from a determination of good moral character, like, for example, certain convictions. Aggravated felonies will eliminate you from showing good moral character. Any conviction for murder, obviously, will eliminate you from that. And there are a whole list of other convictions that can be considered. Some are absolutely disqualifying and some aren't. But that's what they take into consideration. Now, another thing that USCIS is considering very important at this time in making that determination of good moral character is your tax status. Do you owe any back taxes? This can be very important. If you owe back taxes to the IRS or the state government, they want to see that you're making efforts to pay those taxes back before they will allow you to naturalize. I mean, it's not a hard and fast rule, but I can see that in practical effect, that's how they're acting, all right? So if you want to apply for naturalization, I would say enter into an agreement with the IRS to pay back any back taxes that you have. If you haven't filed taxes for years that you should definitely file them. Also, things like child support payments. If you have back child support payments, you want to start paying that off again. All those kinds of obligations. Don't leave any untied loose ends, I would say. Basically, yeah. Those are the important things in determining good moral character.
Okay. And at what stage should someone consider consulting an immigration attorney before applying for U.S. citizenship?
All right. If you have any arrests, any convictions, any tax problems, child support problems, things like that, you definitely want to talk to an attorney and have them evaluate your case before you apply for naturalization. Because if you, say, for example, you have convictions on your record that are bad, when you apply for naturalization, you bring that to the attention of immigration. And you may not want to do that, especially if you've been convicted of a deportable offense, for example. You know, that maybe you don't want to even apply if you have bad convictions on your record. But if that's the case, definitely talk to someone first. If you have absences from the country of 6 months or more, then obviously you would want to talk to a lawyer also.
So for everyone watching, today's conversation has focused on the legal requirements applicants must satisfy before eligibility for U.S. citizenship. Now, residence history, physical presence, as well as good moral character, they all play an important role in the naturalization process, and every application is evaluated on its own facts. Now, if this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We are also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, attorney, based on your experience, how does ImmigrationQuestion.com help immigration attorneys and immigrants like yourself?
Well, they can connect people who have problems with the right attorney, someone who has experience in that particular field.
Thank you for sharing that. Now, before we move into our live Q&A, we just want to discuss one more point. What are some common misconceptions about naturalization that applicants should clarify before filing their citizenship applications?
Well, many people are unaware that you really the English language exam and the history and civics exam are requirements for everyone. There are certain exceptions to that. For example, if a person is of a certain age and has been here long enough, they may be exempted from the English language test, but not from the history and civics test. The only way you can get out of the history and civics test is if you can show that you have a medically determinable physical or psychological impairment that has lasted or is expected to last at least 12 months. And there's a certain form that you must have filled out by a physician to certify that. And it's actually quite difficult to get those forms approved. They have to be filled out in a very specific way. So that's another instance in which you would really have to see an attorney before you apply for naturalization. If you want to be exempted from the English language test or the history and civics test, definitely talk to an attorney.
If you're just joining us, we're speaking with immigration attorney Mary Radzimowski on naturalization, eligibility, residence, physical presence, as well as good moral character requirements. We're going to move into our live Q&A session. This is your opportunity to ask any questions and get educational insights from a licensed immigration attorney. Please drop your questions in the chat, or you can call us live on 516-703-3483, and we will take as many questions as the time allows. Question number 1. If I've had my green card for almost 5 years, can I apply for citizenship before I reach the 5-year mark?
No. Well, it depends. Are you married to a U.S. citizen? Is this person the spouse of a U.S. citizen?
We're unaware of that fact.
Okay. If you are not married to a U.S. citizen, then no, you really have to wait the full 5 years.
Okay.
Well, with one exception, you are allowed, there's a 90-day period before that in which you are allowed to actually file the application, although you're not technically eligible for naturalization. For example, in 4 years and 9 months after you get your green card, you can file the naturalization application, although you don't become eligible for naturalization until the 5-year mark, but definitely not before that 90-day period begins. Okay, so that's 4 years and 9 months. If you have the 5-year waiting period, would be 2 years and 9 months if you have the 3-year waiting period.
Okay. Question number 2. I've taken a few long trips outside the US. Will that stop me from becoming a US citizen?
It depends on how long they are. As I said, you have to have spent at least half of the required period, the 5-year period or the 3-year period, physically present in the U.S. before you are eligible for naturalization. So, for example, if you're dealing with a 5-year residence period, if you were gone for more than 2.5 years in the aggregate, that is, when you add all your trips up together, then you couldn't apply. Okay, so say you took 3 or 4 different trips, and they were 2 months each. Then you would have 8 months outside the country. Well, that's less than 5 years, so you would still be eligible. But if when you add up all the days you spend outside the country in the last 5 years, and they come to more than 2.5 years, then you're not eligible for naturalization. If they come to less than 2.5 years, you are eligible for naturalization.
Question number 3.
Go ahead.
Sorry. I was outside America for more than 6 months. Does that mean I have to start the waiting period all over again?
It depends on whether you maintain your residence in the United States. Now, you really should see an attorney before you file for naturalization, because you're going to have to evaluate whether you can make a good argument that you never abandoned your residence. It's all those factors we talked about, like, for example, did you maintain a residence here? Did you have full access to your residence here while you were outside the United States? Did you maintain a job here that you never quit? Was your family here? Did you take employment overseas? If you took employment overseas, it's going to be very difficult to prove that you maintained your residence here. And then there are other things that you can add in, did you maintain bank accounts here? Any ties to the United States, like that. But you have to look at your own situation. I would say you look at the totality of the circumstances and decide whether you can make a good argument that your residence was never broken, but definitely talk to an attorney.
I'm married to an American. Can I apply for citizenship sooner than 5 years?
Yes, if you're married to a United States citizen and you're living in marital union with that United States citizen for the full 3-year period, you become eligible for naturalization 3 years after you get your green card.
Okay. Now, last question, attorney. There have been recent reports that indicate that the US Supreme Court is considering the Trump administration's effort to limit birthright citizenship. Now, I want to know, what could this mean for families, and should individuals with pending or future immigration matters be concerned about how the court's decision may affect their cases?
Well, actually, that case has been decided already. The Supreme Court decided in favor of birthright citizenship, so that now any child who's born in this country is a United States citizen.
Thank you to everyone who joined us for today's webinar, and thank you to Attorney Radzimowski for sharing your knowledge as well as your practical guidance. You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, as well as register for upcoming live events. If you've missed any part of today's discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you all tomorrow at our next live session. Stay informed, stay prepared, and stay connected. Thank you.
Thank you.